There's not that much to say that hasn't been said. I think all the recommendations for reforming the way New York State operates with eminent domain should be seriously considered. I would say that blight shouldn't be a justification for eminent domain whatsoever, because it's always going to be subjective, no matter what checklist is created. And I don't think, as the late, great Assemblyman Richard Brodsky said, when he held an eminent domain hearing, he said that blight was just Yiddish for poor. And Bob McNamara from the Institute for Justice, a few weeks ago I heard him say that blighted land is actually just coveted land, another way of talking about coveted land. So when they do a blight study, this was the Atlantic Yards blight study, the public, property owners and the general public can respond to it and question it and tear it apart. And Patty Hagan, who's here, and myself, we responded to this, I don't know what it is, 300-page study with a 180-page study and entered it into the record. And the ESDC is supposed to respond to substantive comments, which they were for the most part, and they didn't respond whatsoever in any meaningful way. And when we raised that fact in court in an EIS case, not in the eminent domain challenge, the court basically ignored it both in the Supreme Court and the Appellate Division. So what you get is you get a bureaucrat's piece of fiction.
How many? Who was the? Is that AKRF?
This is AKRF for ESDC, paid for by Forest City Ratner. So that's all the same in both cases. The difference is AKRF worked for Columbia prior to doing this study. By the way, in our case, the attorney, David Padgett, representing ESDC, simultaneously worked for Forest City Radnor, not on the blight study, but on other aspects of the project. And we went to court on that, and he got thrown off for a conflict of interest in the Supreme Court, and that got overturned in the Appellate Division. So there are always conflicts involved with this.
Let me be clear. That attorney worked for?
Simultaneously for ESDC and Forest City Ratner on the Atlantic Yards project. David Padgett, he's I'd say the preeminent attorney representing usually the city and state on development projects. But that was overturned. I'd like responding to what we heard from the ESDC. Darren Block, not sure of his title, talked about how he couldn't give his opinion for reform because they don't make policy and they stay within the bounds of the law. And we've heard over and over here how problematic the law is. I stay in the bounds of the law. I try to. I think I do, as my neighbors do. But what we have found out over the past 6 years, that if you live next to a rail yard, you're basically breaking the law. And what happens then, eventually, when you lose your challenge to eminent domain, and the state takes the next step to take title to the property, you get served with a lawsuit. This is a legal petition that I have to defend, and the defense against it, I'm still not quite clear, is basically limited to procedural issues if they mess something up in serving this. Now, how was this served to me? It was served to Mike Bragcon a week ago, but it was served to me yesterday in my building, and I live in a building that has secured doors to the street. I got a knock at my apartment door on the 7th floor from a process server who threw this into the apartment. And when I chased him down to the lobby of the building, the super was there, and the super works for Forest City Ratner. And I asked him, how did this guy get into the building? Oh, Forest City Ratner called me to let him in the building. Now, Forest City Ratner should have absolutely nothing to do with this petition. They shouldn't know when it's being served or anything at all about it. That's not the case. When ESDC came to my home in October '07 by law to do a visit for an appraisal, their representative, Brown Harris Stevens, you were asking before about appraisals. They did the one for my property, should they take it. When they finished looking at my apartment, and they liked it quite a bit, about an hour later, I heard them down the hall. There's 2 other units on the floor. They were in one of the other units that's been padlocked for 5 years or so, and the appraiser was looking at that unit that's vacant, owned by Forest City Ratner, and Forest City Ratner representative was showing them the apartment. So this is not I mean, it's been said in Catterson's opinion, it's been said here. I'll say more bluntly, the agency acts as a front for the developer trying to do the project. Judge Catterson, in a concurring majority opinion that went against Develop Don't Destroy Brooklyn and other community groups, said that ESDC or UDC is being used as a tool by the developer to destroy a so-called underutilized neighborhood. And I think Judge Catterson, that was part of what got him so angry and aware of what's going on in the state, and with this particular agency that he wrote the eventual opinion against Columbia. But that was a majority opinion, and basically he was with the concurring opinion with the majority. He said he needed to defer to the agency, but this agency doesn't command that kind of deference anymore. In this blight study, they lied about the crime statistics in the project footprint. They did not do a market study. Even AKRF did not do one as they were scoped to do in their contract. They didn't do a market study. Blight, in the end, is about what's going on economically. It's not about a crack in the sidewalk or a bad paint job. Some buildings that were vacant were considered blighted. Some that weren't vacant, some that were vacant were considered blighted. Some that were vacant were not considered blighted. One building was not vacant, and they said it was vacant and considered blighted. So they don't deserve deference. The courts have, in our case at least, have repeatedly afforded them deference, and that's a big problem. So I would say blight should be removed entirely. If that's not impossible, we need to define what substandard and sanitary mean. We need to bring it up to modern times instead of something that was created almost 100 years ago. The public comment period should mean something. There obviously should be a trial. And why should there be a trial? Because we're talking about people's homes, people's businesses, people's leases. We're not talking about a traffic ticket. It's a big deal. Compensation, because Senator Alisi brought it up and asked these guys from the STC about it. The Constitution says just compensation. I think the state Constitution says the same. That does not mean lowball the property owner, force them to go to court to get maybe fair market value. That's what they do. Mike has plenty of experience with it, but they don't attempt just compensation. And that, if you get to the point where you're reforming how compensation is done, somehow, I don't know how you do it, but ESDC has to be removed from the equation somehow. Because the appraisal they've given me, that I'll have to go to court to defend if the state should proceed, is a joke. And they know it's a joke. And I'm going to be paid much more than that eventually, but I have to go to court to do it. They may have to end up paying the fees, my legal fees, which in the end cost the state more than if they had just given me something that was reasonable and fair. So they do not give fair appraisals, is what I've seen personally and with my neighbors, and I know that Mike has told me plenty of stories that are worse than that.